Thanks for having me.
So I'm happy to. So, first off, what do you put the likelihood of a conviction here for the Attorney General?
I think that's impossible to speculate about without knowing anything about the evidence. As a criminal defense attorney, I do think it's important to remember that this is just an indictment, which just means an allegation against the Attorney General, no matter which side of the coin you're on. And every citizen in our great country has the right to be proven guilty of the offense for which they're alleged.
Well, so my assessment of this is he's going to have a tough time in court because of his acknowledgement, basically, to committing this crime only in a civil forum. He basically acknowledged that he did this, and clearly it's against state law.
Sure, I do think that that's something to consider, his civil acknowledgement of the failure to register offense. However, what the Texas Rangers and the special prosecutors have stated over and over again is that when they went in to investigate the failure to register offense, they ended up finding more evidence, which led to these first-degree securities fraud indictments.
Well, so would they spell out? Because I thought, of all my years of reading indictments, I thought this indictment was pretty thin.
You're right. It is pretty thin, but it is also typical of a state court indictment. They generally are not very detailed in factual analysis.
All right. If there was a bombshell as far as securities fraud goes, see, I kept hearing the charges of securities fraud, and I thought that there would be something that comes out that here you have Ken Paxton. He's got 100,000 shares in this Servergy company. The company is going down the tubes. It's not doing well, and he gets these clients of his to invest in the company, knowing that the company was going down. That's the kind of bombshell that I thought I was going to see in the indictment. Because it's not in the indictment, does it mean we don't see that?
Not exactly. The fact scenario that you described could fall within the scope of the indictment because it is phrased, as you said, so minimally, and it leaves all the vague terms up for interpretation for the evidence to show whether or not the state can prove the elements of the offense.
And so I would think, though, that when you're going to indict the Attorney General in the state of Texas, that if you had evidence of fraud like that, you would want it spelled out in the indictment.
That's a good point. I think that if this were in federal court, you would see that. And I think that generally the reasons for a shorter indictment in state court is that they may be still investigating. I have no idea. But they might be leaving room up for further investigation so that the facts can fit the offense, or you never know what's going on.
Well, we've been using this a lot on this show. There's an old phrase: you can get a grand jury to indict a ham sandwich. Do you think some of that was going on here?
I don't know. I do commend Collin County for making sure that the process remained after a few hiccups, and after it ending up in Collin County, they did take several steps to ensure that they have removed as much bias as possible. I think the important thing to remember is the standard, the burden of proof in a grand jury proceeding is the opposite end of the spectrum than the amount of proof it takes in order to convict someone. So I agree with you. It takes almost nothing to be able to indict someone at grand jury level.
All right. We're talking with Nicole Knox, law offices of Nicole Knox, criminal defense attorney, specializing oftentimes in white-collar crimes. So, Nicole, say you had gotten the call from Ken Paxton, and they said, Nicole, I need you. I'm calling in the troops. What's your first move?
I guess it depends on when I get the call.
To this afternoon.
As always, the first place to start is not only with a discussion with your client, but, of course, analyzing the evidence and the investigation. The striking thing is that criminals, citizens alleged of committing crimes, are always at a severe disadvantage in many ways, but the most glaring way, in my opinion, is the investigation. The law enforcement for whatever agency, gets to start investigating whenever they want without you knowing about it. And so then you have to work backwards to try to put the pieces of the puzzle back together.
Is there a problem here when there's evidence that one of these liberal left-wing activists had actually found the grand jurors' names and addresses and dropped off paperwork regarding the indictment to them? Is there anything you could go to a court and get this indictment thrown out on that basis alone?
Yes. I mean, improper influence by a grand juror, I think, would be grounds to revisit the legality of the indictments. However, being able to prove that is extremely difficult.
Even if the grand juror acknowledged that, somebody showed up on my front doorstep?
Well, then the second part of the analysis after that admission would be whether or not that improperly influenced the grand juror's opinion. And then you only need 9 of 12 grand jurors to agree to indict an individual. So it would depend, I guess, potentially on what side of the coin that grand juror was on.
All right, so when you're defending a guy like Ken Paxton, is the best hope of keeping him – see, I think a guy like this, when you get charged with felonies, everyone's talking about should he resign, should he step down, and keeping his political career alive. Really, you've got to worry about whether or not you're going to prison.
Oh, of course, especially in a felony of this magnitude. It's a first-degree felony punishable by up to 99 years. But I think it's an interesting issue of whether or not he should be able to keep his job. For better or worse, we're going to hold the Attorney General, and I think we should, to a higher standard than the normal citizen because he is the top law enforcement agent of the state. I think it'll be interesting to see what they do with that. If you compare it to usual law enforcement officers or agents who are under investigation or who have been indicted and are pending trial, then usually the process is, and it's up to each department, but usually the process is for them to take an administrative leave so that they're stepping down from their day-to-day activities, but they have not formally resigned.
Yeah, that is true. Even among police officers, they could be pulled over for drunk driving, and they often take an administrative leave. The only defense that I have for Ken Paxton on this is because after reading the indictments, and there was really no new information in these indictments that hadn't already been played out in the campaign. Dan Branch, who ran against him in a Republican primary, had used this stuff against him. The Democrats threw all this stuff at him during the campaign. He can make the argument that the voters of Texas already knew all of this stuff. You want me to step down? They voted me into office already knowing there's no new allegations leveled, and we thought they were taken care of.
Yeah, I think the counter-argument to that is that the new information is the misrepresentation and failure to disclose material information about the securities fraud, about receiving compensation in shares, and that the complainants, his customers, might not have made the investments otherwise.
Okay. Interesting. It surely will be it'll be a circus to watch this play out, I'm sure.
Yes, I think we'll all be reviewing this case for a while.
Hey, well, Nicole Knox with the Law Office of Nicole Knox, criminal defense attorney, I appreciate you sharing some time with me.
I appreciate being here. Thank you very much.